Welcome to our first lecture covering OSHA. Let's go ahead and begin. Here's a little introduction. People die at work. People die at work on a pretty regular basis in our country. And in fact, in the last several years, the numbers have been going up a little bit. So we have over 5,000 deaths related to workplace injuries every year in the United States. That number isn't huge, but when you also consider that many people are injured at work, many more people are injured at work who are not actually killed, but may suffer uh, amputations, debilitating injuries of all kinds, that number is probably more like 3 million situations a year. And workers' compensation payments are about $1 billion a week. So, safety in the workplace is a real issue in our country. Obviously, it's a real issue for people who are being injured and who are facing the possibility of being injured, but it's also a major cost for businesses as well. And of course, it can have huge morale implications for our workforce, in addition to just the human loss and the suffering that happens. The statute that we're going to focus on in this course that it primarily addresses workplace safety is the Occupational Safety and Health Act, which is what we call OSHA. And it is designed to cut the number of fatalities that we'll have in the workplace. Obviously, there's no way we'll ever get this to zero, as wonderful as that would be, but it has significantly reduced that number, and it has also significantly reduced the number of workplace injuries. So even though 3 million sounds huge, it is significantly less than what it once was. But OSHA is not a perfect statute, and we'll go through in this presentation some of the less pleasing aspects of OSHA. So we'll kind of talk about it from lots of different perspectives. Let's get started on that. We're going to talk generally about OSHA in this lecture, and then in subsequent lectures, we'll complete our OSHA material and go into some discussion about workers' compensation. If you are somebody who hasn't grown up in Texas or hasn't spent much time thinking about workers' compensation law in Texas, it is especially important for this course that you watch workers' compensation. This is one of the relatively few areas in our course where there are important statutory aspects to Texas law that you needed to know about. And so even if you know a lot about employment law generally, if you aren't familiar with Texas law in some of these areas, this is one of those few areas, payday laws and this area where we see Texas statutes really becoming front and center. So be sure to watch the rest of this lecture series to be really up to speed with what you need to know about workers' compensation law in this state. We're going to start with an overview of how OSHA works. Okay, so this is our statute. It was passed in 1979, so it is a relatively new law compared to, say, Title VII and other laws. But of course, it actually came after the Americans with Disabilities Act, so it's not super new. As you can see, this was perceived, or as you can probably guess, this was perceived as a more intrusive area of the law because what we're doing is we're telling employers how to run their business. We didn't really do that with Title VII. We just said don't discriminate, but we didn't tell people, how you should staff this particular function or how you should keep your workplace safe. OSHA gets much more into the weeds of how, especially an industrial or warehouse operation is set up. So it's really much more intrusive into the business model. And I think that's one of the reasons why this law came after we had the discrimination laws. And again, what the Act does, what OSHA does, is it establishes minimum workplace safety standards. It tells employers that this is how you have to do this. We don't care if you like it. We don't care if you do like it or don't like it. You've got to implement these safety features. Prior to OSHA, there really wasn't much in this area on a federal level. You will see, we won't talk a lot about other states' OSHA equivalents. In Texas, we don't have an OSHA equivalent. The big OSHA equivalent, though, that you will hear about if you follow this literature very much is Cal OSHA. and you probably have already guessed where this comes from, state of California. OSHA does allow states to have its own version of OSHA. And if the state law provides more protection for employees, then generally speaking, with some notable exceptions, but generally speaking, the states are allowed to have those additional requirements. And Cal OSHA is one of those. It does have more onerous requirements for employers and obviously, therefore, more protections for employees. So you will see in some states that the OSHA requirements are just you could call it a floor, and that in those states there will be additional protections above that. Now, of course, an employer is completely entitled to have additional protections above what OSHA requires, and many employers routinely do that. And we'll talk about sometimes employers are actually required to do that. Um, but one of the interesting things about OSHA rules is that you have to follow the rules even if you want to do something more safe. And sometimes there can be a tension there because let's say, what the rules require is that you do A, and you decide, well, you know what, we don't want to just do the minimum. We want to do something much better. So we want to do B. And B is clearly safer than A. But you still have to do A. You can do B too, but you have to still do A. You can't say, well, I'm doing B, which is clearly better, so I don't need to do A. You always have to do what OSHA requires. You can do some additional stuff on top of it, but you can't say we're doing more and better stuff so we don't have to do this other thing. And that can be a source of tension in a business. So sometimes businesses will be doing B and then they will still have to do A, and their employees are like, but why do I have to do A? We've already covered that by doing B. And the employees oftentimes get frustrated. And it's understandable because most of OSHA's safety rules aren't very comfortable. They're kind of the equivalent of wearing a mask in class, right? During the pandemic, we needed to wear the mask in public. That's not very comfortable. And so let's say that we developed a technology that if you sprayed something all over your body before you went on public, you couldn't get the virus and you couldn't spread the virus. And this was 100% foolproof spray that everybody put on. But if this were in the workplace, OSHA might well still say you have to wear the mask, even though the mask serves no purpose at this point because you're spraying the spray all over your body. Well, you can see how employees would be like, I don't want to wear this mask. I'm already fully protected from whatever this hazard is. The mask gets hot, it's hard to talk. I don't like it. And so as a result, many times employees will kind of rebel and not wear it, at least try not to wear it. So, maybe they take it off when the boss isn't around. And you can see how this can create some tension. The employer is forcing employees to wear this kind of silly mask because it doesn't help because of the spray that everybody's spraying, and yet they have to follow the OSHA requirements. So OSHA can result in some surprising tensions. It is not always the case that employees want to do the safe thing. But the employer is required to make the employee do the safe thing. One of the things in a workplace that happens is that, when you first arrive at a workplace, and I think we've all seen this, you're kind of excited, you're learning, you're seeing all the dangers that are there. But after you're there for 6 months, a year, 2 years, 3 years, 4 years, whatever, you've become kind of immune to seeing some of the dangers. You've kind of become acclimated to those dangers, and you haven't been hurt yet. And so you kind of have this feeling of, oh, that's a piece of cake. I don't have to worry about that. A comparison might be the way we drive. When we, first got behind the wheel when we were 15 or 16, we were very careful and we had our hands just so, and we were looking and following all the rules. And, as adults, we might be a little bit less careful about all of those rules because the 99.999% of the time we're not in an accident. And so it feels like that's probably not going to happen to us. And so when your boss tells you, no, you have to have your hands at 9 o'clock and 3 o'clock when you're driving, you kind of feel like, oh, get over yourself. I'm an adult. I can drive a car. I've been doing it for years. That sometimes is the reaction that employees have in that situation. It's harder to do it that way. It takes more time. It may be more uncomfortable. Nobody likes somebody looking over their shoulder. And so as a result, sometimes employees are the people who are most OSHA resistant. But a defense that employers do not have is to say, you know what, we told employees to do this and they just didn't. And so what are we supposed to do? Well, OSHA would be very clear about saying, fire those employees. Fire people who don't follow the rules. You fire one person who doesn't follow the rules, you'll soon discover everybody else is following the rules. You may say, what? OSHA wants us to fire people? I mean, isn't that kind of the reverse about what we saw with the EEOC and other of these statutes? Well, you're right. Those statutes don't want us to fire people usually, right? Doesn't want employers to fire people. But OSHA sees firing or disciplining people for safety violations to be a really, really important part of keeping the workforce safe. It's not that OSHA are a bunch of meanies. I don't think they are. Maybe they are, but their point is workers are not going to be safe all the time simply because they know it's in their long-term interest. I mean, if that were the case, everyone would have worn seatbelts before they were legally required. But I mean, many students in this class weren't around before seatbelt laws were in effect. But those of us who were, I can promise you, the vast majority of people did not wear seatbelts before they were legally required, even though the evidence was very, very clear that you were much, much safer in a seatbelt. And the reason why we didn't, it was a little bit uncomfortable to wear a seatbelt. And same way with workers who don't routinely see accidents at work. They aren't going to be thinking about those accidents. They're going to be thinking about, oh, this is a little uncomfortable to do. So OSHA says, look, just like those laws that require us to wear seatbelts incentivize us because we know we'll get a ticket or we know we'll be in trouble if we don't put the seatbelts on. OSHA says, listen, you need to make employees recognize that there's going to be a negative consequence if they don't wear the mask or follow the safety rule. It doesn't have to be termination. In fact, usually it won't be termination for the first offense. Maybe it's a disciplinary comment the first time. Maybe the second time it's a week suspension. Maybe the third time it's termination. But you need to have some teeth in the rules, in OSHA's opinion, in order to motivate the employees, to incentivize the employees to follow the rules. So let's go forward and talk a little bit more detail. So OSHA is actually, it's a little confusing here. OSHA is the name of the statute, the Occupational Safety and Health Act. Here's the name of the whole statute up here. But it's also the name of the agency that enforces it, the Occupational Safety and Health Administration. It's going to get confusing in this presentation because sometimes when I say OSHA, I'm going to talk about the statute. And sometimes when I talk about OSHA, I'm going to talk about the agency. I'm going to try to be clear. Hopefully the context will make it clear, but they do have the same nickname. There's there's two other agencies that are relevant. This, of course, is the most important, and you'll want to add this to your Quizlet, the name of the agency that the Act created and that is responsible for administering OSHA. Then we have two other agencies. They are also in red, so you know that these are Quizlet terms you need, but they're significantly less important. One is the Occupational Safety and Health Review Commission. I suppose people who work with OSHA a lot have this nickname, this abbreviation in the top of their head, but I don't. I definitely dealt with OSHA in my professional career, but it wasn't a big part of my job. And so don't worry about knowing the abbreviation. If you do, great, but focus on knowing the Occupational Safety and Health Review Commission. And as you can see, it starts the same way that OSHA starts, right? So instead of having administration, it's the Review Commission. It's important to keep in mind that this is separate from the actual OSHA agency, and it hears appeals from OSHA rulings. So this is kind of the equivalent of the National Labor Relations Board, the NLRB that we saw with respect to labor activities. It doesn't have the same ending. It doesn't end with the word board. It's called a review commission, but it functions in a similar manner. Now, NIOSH is something that is important to know about. These are the scientists. These are the people that tell OSHA this is how you keep the workplace safe. They provide scientific and technical support. Very well regarded agency. These are scientists, chemists, doctors, people along those lines who evaluate the risks in the workplace and who come up with solutions and establish a level of safety that is appropriate for the workforce. As we've talked about in the past, there's a really important distinction between employees and independent contractors. We've seen that with the National Labor Relations Act. We've seen that with the Fair Labor Standards Act. We've seen that with Title VII, the ADEA, and the ADA. We've seen it really with every single statute we've dealt with, and OSHA is no different. It is not the responsibility of the principal or the employer to protect independent contracts under OSHA. Now, I'm certainly not saying that's a bad thing to do. It's a good thing to do. But OSHA isn't about handling independent contractors. Part of that reason probably is that back in the 70s, independent contractors were not nearly as common as we see today. I mean, certainly there were plumbers and people like that who would be called in to address issues along those lines. But there was less of a gig economy than what we have today. But statutorily, OSHA really is just designed to address employees. And in a way that makes sense because employers are required to provide training to its employees, but not to independent contractors. And much of the work of OSHA is training employees. And so it makes sense that it's related to employment. Another thing that many people fault OSHA for is that OSHA doesn't do any kind of cost-benefit analysis. So there might be some very slight increase to safety of doing procedure Q. But it's expensive. All of the employees hate doing it. It's uncomfortable. And so both the employer and employee might say, we don't want to do Q. It's a hassle. We're willing to accept the slightly greater risk that there will be a workplace injury. The people at OSHA do not care one little bit. They don't care whether the health benefits are highly outweighed by the increased costs or increased hassle associated with this program. There is no cost benefit analysis. Maybe only, maybe doing the safety procedure will cause, instead of, let's say in this industrial workplace, over the course of a year, 7 people need stitches because of a workplace injury. And if everybody does this one action, it will statistically reduce that number to 6 people needing stitches. So one person is saved the hassle of stitches, but it costs the employer $200,000 a year, and it means that every single employee has to go through 1 hour of training every year over how to safely do this. And the employees are like, no, this is a workplace of 1,000 people. This is ridiculous. We have to be trained every year for this. I'd prefer to get the stitches. But again, OSHA doesn't care. OSHA is not going to do a cost-benefit analysis in the majority of cases. So when there is a violation, I'm sorry, here we go. There are 3 levels that OSHA has established. The first is de minimis. We saw this when we were talking about religious accommodation. Remember, we talked about that the cost of religious accommodation, reasonable accommodation, couldn't be more than de minimis without it becoming an undue hardship. And we discussed at that time that de minimis meant trivial. Anything that was a significant cost was not de minimis. So even if it was a very small cost, financial cost, it was not considered de minimis. De minimis here obviously isn't talking about cost. This is a violation error. So this is more of a technical violation. Imagine, for example, that again, going back to this made up, I'm not saying there is a rule like this, but this made up rule Q that requires everybody to go through an hour's worth of training to avoid a particular type of injury every year. Well, let's say your entire workforce does get trained. Everybody actually does go through the hour training, but somehow or another, 20% of the workforce, their paperwork got lost. Somebody forgot to file it and nobody can find it now. Well, that would be a de minimis error. Everybody got the training, but you can't prove it. But again, OSHA goes out and actually interviews the 20% of people who supposedly weren't trained, and everybody claims they were trained. They know the material that was in the training, and they can cite particular days that they went to the training. And so under those circumstances, that would be a de minimis, a paperwork error. Obviously, OSHA doesn't treat that as an especially serious issue. Then we have non-serious situations and serious violations, and you can probably connect the dots there. We're going to look at Section 5A in just a second, but first of all, let me describe what Section 5A talks about. So the first thing that employers have to do, they have to follow all of the rules of OSHA. Okay, that's pretty obvious. You got to follow the rules, right? No big surprise here, but this is the part that may surprise you, the general duty clause. We'll talk a lot about the general duty clause later on, either in this lecture or a subsequent one. But this requires that the employer not just follow the Department of Labor rules, but also furnish a workplace free of hazards. This is under the general duty clause. So an employer isn't doing enough simply if it follows all of the rules that already exist in OSHA. It has to evaluate its workplace and say, you know what? We see a danger over there, but OSHA doesn't have a rule about that. But we still have to fix that danger. We can't just say, oh, wait a second, OSHA, there was no rule about this, so we didn't fix it. No, OSHA says this general duty clause makes you the problem solver, you, the employer, the problem solver. Now, I don't want to make you think here that OSHA just has a few rules. Here's the example I have here of a circle. Imagine these are all the hazards in a workplace, and all of the shapes are OSHA rules to address particular workplace hazards. But you'll see there's lots of gaps. There's this whole area where there are no OSHA rules. There's this whole area where there's no OSHA rules. There's this whole area where there's no OSHA rules. It doesn't mean that the employer gets to just kind of, oh, well, whatever, somebody gets hurt, too bad for them. No, the employer is then required to come up with rules. Oh, well, this is going to be our rule for this particular risk, and this is going to be our rule for this particular risk, and this is going to be our rule for this particular risk. The employer can't just ignore these gaps. Now, this picture that I've drawn, let me go ahead and remove my lovely artistic statements. This picture is a little bit misleading because while there are gaps, there probably aren't this many gaps because there are a ton of OSHA rules. So this is probably more of a cluttered circle of things that can happen badly in a workplace. But again, the goal I'm trying to get at is the general duty clause is all this blue area. We still have to worry about it as an employer before we go forward. So I'm going to show you the statute here, at least a little excerpt from the statute. And here we have, you'll see this is A. This is section 5A. It's numbered differently actually in the actual code. So the first one is, shall furnish to each of his employees employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to his employees. So this is the general duty clause. Now you may notice something immediately. It's like his. Why are they saying his? Why aren't they saying his or her? Why are they saying its? This is an example of somewhat dated statute. I apologize for the sexism in the statute. The other one is, again, you got to follow the rules of the of OSHA. And so I have them stacked in my PowerPoint. This one I have stacked first and then this one, but they both apply obviously. So in the statute they are in the reverse order. Let's go on to our next slide. So now we're going to discuss some specific standards. Now there's so many standards. There's just no way I'd be able to cover even a very small fraction of them. So I'm not going to pretend to do that. They are obviously very industry specific. So for example, if you go to work for a shrimping in business, you're going to know a lot, and you work in the legal department there, you're going to know a lot about shrimping boat protections. If you go to work for a chemical plant on the Houston Ship Channel, you're going to learn about completely different safety specifications. If you go work for a warehouse operation, say near a DFW airport in the Alliance area, there are completely other safety rules you need to know about. Nobody, I don't think, knows all of OSHA's safety rules. It would just be too much to be able to get that much into the weeds because they're very specific to industries and to very specific safety concerns. And of course, they're changing as technology and the workforce changes. So let's look at these. So the types of areas where we see standards are: how does the physical layout of the workplace have to exist? What kind of training do all the employees need to have? What kind of medical examinations are required for particular positions? How are standards set in that workplace in terms of productivity standards and safety standards that are unique to that particular operation? What type of voluntary compliance programs are OSHA encouraging workforces to implement? Here are two that I have again put in red, so I'm a little bit more focused on these definitions. Let's talk about emergency temporary standards. This might arise in a new industry, or it might arise in an industry that has had a change in how they do things, perhaps because of technology or perhaps because of some problem sourcing certain components of the product. So these are standards that are imposed by OSHA, but they haven't gone through that typical rulemaking process. The administrative rulemaking process is very regulated. And it takes a long time because there has to be a hearing period, there has to be a comments period, all kinds of stages to this. And that process takes months at least. But if people are getting injured at work, OSHA quite reasonably doesn't want to say, "Hey, go ahead and die at work. We'll be back with you in a few months, giving you the safety rules. If you're still alive, then you'll be safe." That doesn't make any sense. OSHA wants to protect people every day, and so as soon as they see, wait a second, people are getting injured in this scenario, we need to put up with a solution. We need to create a solution right now, and then and once we set it up, then we will set up the rulemaking process. And probably through the rulemaking process, we'll end up tweaking our emergency temporary standard. But at least we've got something now to protect people. And again, we have these emergency temporary standards when we feel, or not we, but when OSHA feels people are in grave danger. And many times these have to do with exposure to substances in the workplace. Once upon a time, nobody knew asbestos was dangerous. People used it. It was a great flame retardant. Then suddenly, one day, people realized, oh my gosh, people are dying from asbestos exposure. And so we got to fix it, like not in 6 months. We've got to fix it today. That's where we have these kind of emergency temporary standards. Another important term here is continual training requirement. OSHA requires the employees constantly train new employees, and also employees who aren't new but are being transferred to a new position. Imagine that Bob is in Department A. He's off work today. You have a lot of work you need to get done in Department A, so you bring in Larry from Department Z over here. Larry's never worked in Department A. He's been with you for years. He's a good worker. He knows exactly how to safely do his work in Department Z. And A and Z have a lot of things in common. But you know what? Before Larry starts working in Department A, he needs to get all the training for Department A. Um, because honestly, the most dangerous day to work in a department is oftentimes the very first day, because you haven't figured stuff out. You're a little clumsy. You're a little overwhelmed with all the new things going on. And so if we allowed people to work occasionally in a department to which they had not received all the safety training, those individuals are the ones most at risk. And so we don't allow, OSHA does not allow Larry to just pop into that department for a day and then pop out without getting the training. For that reason, companies usually cross-train workers. So let's say again, in Department A, there's 10 employees. And if this department regularly needs all 10 workers there, I mean, some people are going to be on vacation or sick or they're going to quit. So you'll need to have people in maybe departments R and departments Q cross train in A. And you may have some of the people in department A cross train in departments B and L, for example. And so in that situation, when A has an opening or somebody's absent, that cross-trained person from Department R can just slide right on in into that position, or maybe the cross-trained person from Department Z. That's an efficient way of managing it. You also need to remind people about training. It's not one and done. People forget. People become maybe more careless as they become more habituated to a particular job. And so it's good to continually retrain folks so that they will know and be refreshed on how to safely do things. Sometimes we'll see that there are more specific standards that conflict with more general standards. And in that situation, you always apply the more specific standards. So if there's a rule that says you ought to wear a, a safety vest in this situation, in a generalized industrial situation, but then there's another rule that says a particular type of safety vest is necessary for this particular industry, then the more specific rule is going to apply, even if they tend to conflict. And that's generally the rule for interpreting statutes and regulations more generally. Let me give you an example that doesn't have to do with OSHA that will help explain this. Let's say that there is a statute that says, um, um, let's say a statute says you have to be 21 years old before you can buy a beer, wine, or liquor. So that's a very specific statute. It explains exactly how to calculate the age. We'll say it even says 21 days, 21 years from the date of birth or something along those lines. And then there's another statute that says any adult who drinks a beer, any adult who buys an alcoholic beverage needs to pay XYZ tax. Well, that statute isn't nearly as specific about who can buy the wine, beer, or liquor. It is just says the term adult. And so if you just had that statute to use, you might think, well, 18-year-olds can buy wine, beer, and liquor because they're legally adults. 19-year-olds can, 20-year-olds can. That seems to conflict with this other statute that says you have to be 21, who's obviously a 21-year-old's an adult, but also 18, 19, and 20-year-olds are adults. So there seems to be a conflict there. But which one's more specific? The one statute is about tax law. The other statute is about eligibility to buy the alcohol. And so the tax law one is general with respect to who is eligible to buy the liquor or beer or wine, but the one that's specific is the one that controls. And that same rule applies to OSHA. About more specific is the one that needs to be complied with. And again, employers are going to have more than one standard. Almost all employers are going to have some kind of white collar area, some kind of office setup. They will also have, very likely some industrial type setup if they, make widgets or they manufacture chemicals, or they're a refinery where they process oil, those types of things. They may or very likely will have several different standards, some warehouse standards, some industrial standards, some office standards. And it's important for them to get into the weeds and figure out exactly what is the particular rules that they have to follow. And of course, they wouldn't have to follow the industrial rules in their office building, and they wouldn't have to follow the office rules in their industrial building. So there would be some differences. They might have to follow lots of different rules, but they wouldn't have to follow all the rules in every single location. I'll give you an example of this. When I was at JCPenney, we had many different facilities. We had, obviously retail stores. We had warehouses where the merchandise that would be going to stores would eventually, would be stored. We had office buildings. And in the industrial or the warehouse type situations, we would be required to keep a particular log that was required for industrial situations. But in the office situations, we would keep a separate log, a different type of log. And each log would be kept in each unit. So the particular log that this particular industry was required to use, we would make sure that that particular unit was using the right kind of log. So that's an example of how individualized the rules are. So here's just some example of some standards. There are standards about how much lead and benzene and asbestos exposure workers can have. There are rules about how certain machinery can safely be operated, paper balers, things like that, cranes. There are rules about how welding can be done safely. There are new rules about noise and ventilation. Who has to wear earplugs? Who has to wear masks to filter the air? Those types of things. There are rules about respirators and eye and face protection. All of these things, and safety rules. Where do the safety kits have to be located? Who has to be trained to do various safety procedures? What needs to be in those safety kits? Again, those are going to vary from industry to industry. Here's an example of a noise exposure standard that explains kind of how that looks. I've actually pulled up this noise exposure standard in, the regulations. So here we go. Let's look at that for a second. And here we have the noise exposure standard. And you can see here's the decibels. This is how long you can be exposed to these decibels. So you can work 8 hours a day with 90 decibels, but you can only work half an hour a day at 110 decibels. So again, you can see it's very, very detailed and specific, which in many respects is great because the employer doesn't want there to be a lot of gray area where I'm not sure if I'm complying or not. The more detailed, the more specific it is, even if the standard's difficult to comply with, the better it is because the employer can say, oh, yeah, I'm doing that. Or I'm not quite there yet. I need to up my game and get to that place where I'm in complete compliance. Let's look at what needs to be proven for there to be a violation of a safety standard. So this is what OSHA would need to prove against a particular employer. So OSHA would have to show that an applicable standard exists, and of course one of those standards is going to be the general duty clause. The OSHA would have to show that the employer did not comply with the standard, and also that one or more employee was exposed to or had access to the standard. Now notice here this does not require that an employee was actually injured or even had a near miss, but simply that it could have happened that there was an injury. And finally, that the employer knew or should have known about the hazard. Now, should have known is a really big category. The idea here is that if anybody in the workplace knew about it, then the employer knew about it, right? Because the employer, those workers are agents of the employer. And so it's very difficult for the employer to say, let's assume that 1, 2, and 3 are satisfied. It's going to be very difficult for an employer to persuade the court that somehow or another, with 1, 2, and 3 being satisfied, somehow or another, it's off the hook because 4th wasn't satisfied. I mean, obviously, some employee was exposed to the hazard, and so this is rarely going to be an exit strategy for the employer. So the process, as I said before, we had those emergency standards that we use, emergency temporary standards that we use when we're in the rulemaking process when there's an urgent situation. But the actual usual method for adopting safety standards is lengthy, arduous, and frankly, quite politicized. This area is much more politicized, frankly, than Title VII or, well, I'd say Title VII and ADA and ADEA, because it's very expensive in many cases to comply with OSHA. And as a result, employers are very interested in how these rules are going to play out. As a result of the politicization of OSHA, there are lots of standards that you would ordinarily think would exist that actually don't exist. And one of those standards, I think we do now have a standard for benzene, was benzene. Benzene is is a very dangerous chemical, and workers who are exposed to it are at very significant risk of very significant health consequences. But it's also very difficult to reduce or eliminate benzene from exposure. And so you're up against two things. It's really expensive and it's really bad. And as a result, OSHA was really struggling with how to come up with a rule because it was such a politicized topic. So for a long time, areas like this were covered by the general duty clause. Now that's crazy. But of course, the general duty clause fills the gap. So even when there wasn't a benzene rule, the employer was still required in the general duty clause to protect its employees from benzene. Um, Areas that we see continued politicization of OSHA is in the area of repetitive stress injuries. Probably what you're familiar with the term for this is carpal tunnel syndrome. People, especially, and this applies both in the traditional work environment that's white collar as well as the traditional work environment that's blue collar. Carpal tunnel syndrome or carpal tunnel situations are typically when the wrists and the hands repeat an action many, many times, and that causes problems with those particular joints. And so it requires redesigning the work so that the worker has periods of rest or performs that task in a variety of different ways so there isn't as much stress on the joint. So people working on an assembly line, let's say I'm on an assembly line and my job is to tighten 4 screws as the appliance that is being assembled goes by me. Well, I'm doing that same action, a million times a day. I am going to be a big candidate for getting carpal tunnel. So one way around that might be instead of me having tightening 4 screws, maybe on the first appliance, I tighten the screw. Then the next appliance, I turn the item over so the next person can tighten the screw. And the third one that goes by, I do some quality assurance checks to make sure that the device A is connected to device B on the machine. And so that way I get some rest and I'm using my wrists in different ways. And so I'm less likely to get carpal tunnel, or at least be less likely to. So that would be a way that an employer could exercise his responsibilities in the general duty clause in the workplace. But, again, or let's say I'm a typist. Well, obviously typing all day involves many of the same movements of the wrists. So instead of having, let's say you have 4 office people, one who's the receptionist, one who's the file clerk, one who types all day, and the fourth is the one who takes dictation. Well, you might want to have each one of those 4 workers do each one of the jobs 2 hours a day, maybe even in a 1-hour envelope, 1 hour in the morning, 1 hour in the afternoon. That could be a way to reduce the likelihood of carpal tunnel syndrome developing. But you can see how this really requires employers to think through lots of different issues. And lots of times employees, I mean, obviously if they're injured, they don't want to be injured, but they may think, I don't really want to be a receptionist. for 2 hours a day. I like to type. I'm good at it. That's what I want to do. That's maybe has higher prestige. Maybe that's a position that earns more money. I want to earn the money. I don't want to see a reduction in my pay because the receptionist earns $10 an hour. Me as a typist earns $15 an hour. I don't want to give up $10 a day. So you can see how there's all kinds of groups that are going to be concerned about this. And for that reason, OSHA has been delayed in developing some of the safety rules in some of these most politicized areas. So this is a case that came down from the U.S. Supreme Court. Let's look at the issue. You are not responsible for knowing the name of this case, but it is a case that you want to know kind of the answer to this issue. So does OSHA have to determine the cost of the cost of the standard? Oh, okay. So does OSHA have to do some kind of cost benefit analysis? In other words, do the costs of whatever the standard is, whatever the employer has to do, does it have to bear a reasonable relationship with the benefits that will accrue to the workers in terms of additional safety? The answer is no. There is no need to do cost benefit analysis. And here we have the answer here. The Supreme Court held that Congress defined the basic relationship between costs and benefits by placing the benefit of the worker's health above all other considerations. Therefore, there is no need for OSHA to say, to consider, well, gosh, that's going to cost that employer $1 million and it's only going to result in a slight increase in safety. OSHA can do the cost benefit analysis if it wants to, but it isn't required to. And the employer doesn't have a basis for objecting because a cost benefit analysis wasn't done or resulted in a very lopsided analysis. You don't need to know the name of this case, but you do need to know this concept for future tests. Let's consider retaliation. Quite obviously, the way that OSHA hears about most violations is through employees. Employees call, oftentimes anonymously, but sometimes not, complaining about unsafe workplaces. We want we want those workers to do that. We want them to know that they're safe from the possibility of retaliation. Otherwise, we won't know about these risks. So OSHA does provide protection from retaliation for these whistleblowers. And this is what an employee who's claiming retaliation at OSHA needs to prove. First of all, that he or she was engaged in protective activity. He or she was whistleblowing. I mean, if you didn't blow the whistle, obviously you aren't a whistleblower. So if you didn't complain about it to OSHA or whatever the agency might be, then you are not a whistleblower. You also have to show that the employer knew that the whistleblower blew the whistle. Obviously, if the employer didn't know the whistleblower blew the whistle, the employer can't be discriminating against the whistleblower for whistleblowing. So that's just kind of common sense. Then, of course, the employer has to have subjected the whistleblower, I guess I should have left out an M here, him or her, the whistleblower, to an adverse action. Now, obviously a termination is an adverse action, but there can be things significantly less than than termination that would qualify. So obviously these three aspects are pretty much kind of definitional in the idea of having a whistleblower retaliation situation. The fourth thing is the only thing that may be a little bit of a leap here, and that is that the protected activity, the whistleblowing, is connected to the adverse action. This can be a little bit difficult to prove. So let's say I complain to OSHA about my employer because my employer is not requiring workers to use a harness when they climb certain tall ladders. The employer knows that I complained because I was complaining within the facility about it, and the employer heard from other workers that I was complaining within the facility, and then lo and behold, OSHA comes in. So the employer was able to connect the dots. The employer shortly thereafter fired me. So 1, 2, and 3 are satisfied. But 4 happens, you know what, in addition to me being a whistleblower, I was also stealing from the employer. And the employer had already been aware of the fact that I was stealing and was doing an internal investigation. They had me on camera sneaking stuff out of the facility. In fact, that may have been my motivation for whistleblowing. I knew they were on to me, and I was trying to figure out some way that I could preserve my job. And I thought if I was a whistleblower, they couldn't fire me. But they do go ahead and fire me anyway. Well, I'm going to have to show that my whistleblowing led to my termination. That's going to be hard to do if they have me on camera stealing, especially if they can demonstrate that they already knew about my stealing and were actively investigating it prior to me becoming a whistleblower. Now, of course, if I'm a whistleblower and a thief too, but they are after they know I'm a whistleblower, they intentionally say, well, let's see if we can find any dirt on Groover. Let's go back and look at all the video cameras of her at a workstation, hoping to find some violation. Oh, she stole from us. This is perfect. Well, then, because their motivation for finding out my theft was to retaliate against me because of my whistleblowing, I would still be protected. So even if I had a terminatable reason that they actually terminate me for, if they found out about it only because they wanted to fire me as a whistleblower, then I would still have a retaliation claim. Okay, so now let's talk more about the general duty clause. Um, I've already shown you the general duty clause before, but here it is. Each employer shall furnish to each of his employees employment and a place of employment which are free from recognized hazards that are causing or likely to cause death or serious physical harm to his employees. Now, serious physical harm is not, losing a leg. I mean, it certainly would be losing a leg, but it doesn't have to be something huge like that. Carpal tunnel is serious physical harm for sure, even though a person, they are not, I mean, it's a serious condition, but it's not a desperately serious condition that would cause somebody to die from. And so this is that general duty clause. This fills in the gaps. OSHA can't come up with a solution to everything. I like to compare the general duty clause kind of to the common law. And OSHA rules are kind of like statutes. We talk about the common law. We think about these are all the things we need laws about. The legislature comes in and passes a law here and passes a law here and passes a law here and passes a law here, but never passes a law to cover this topic. But it doesn't mean we don't need law on that topic. I mean, if a dispute arises, we need somebody to solve it. So the judge steps in at that point and comes up with common law to address that issue. We could almost say that the employer is doing the same thing here. The employer can't rely upon an OSHA rule because there is no OSHA rule here. So the employer kind of has to act a little bit like that judge and say, well, what would be something, how can I as the employer furnish to all of my employees a place of employment that is free from recognized hazards? How are we going to do that? Maybe a safety harness is needed. Maybe we need to reduce the level of noise in this particular area. Whatever the thing is, that's kind of like the equivalent of the common law. And here's a definition of the general duty clause. It's a provision of OSHA requiring that employers furnish to each employee employment and a place of employment free from recognized harm. So you can see I have the definition here. Basically, it's directly from the statute. An employer is deemed to have constructive knowledge. We talked about constructive discharge earlier in this course, and that is when an employer forces an employee out. The employee actually resigns or abandons his job, but the employer forces the employee out by making the employment situation so miserable. We call that constructive discharge because it's not literally a discharge. The employer didn't literally say to the employee, we fire you, but the employer did things in a way that essentially got to that part. Well, constructive knowledge is a similar idea. The employer didn't actually have knowledge of it, but should have had knowledge of it because obviously an employer is supposed to know what's going on in his place of employment, right? I mean, that's kind of his job to do that. And so an employer who says, I had no idea that was going on in the warehouse, that employer is not going to be very persuasive to OSHA because OSHA's response is going to be, well, you should have. I mean, maybe you did, maybe you're lying to us now, maybe you did know, or maybe you're telling the truth and you're just really stupid. But we don't really care because you should have known what was going on. You should have had constructive knowledge. You did have constructive knowledge of it. And so you don't have to, the employer doesn't have to have literal actual knowledge of it because that can be hard for OSHA to prove. But the employer has constructive knowledge about it if the industry recognizes the hazard, even if the employer was a little bit out to lunch in that area. Similarly, the employer has constructive knowledge about what's happening in his workplace. So let's say the employer trains all of his workers. This is how you should keep yourself safe and follows the rule book exactly about how to train the folks, provides all the safety gear, and then never looks back, never supervises those workers. And the workers, for the first few weeks maybe follow all the rules, but then they start getting careless with it. But the employer doesn't monitor it, doesn't pay attention to the fact that the employees are no longer using the safety equipment, are no longer following all the safety steps. Well, the employer can honestly say, we had no idea because they literally didn't. But the OSHA is going to say, well, that was your job to know that. So that in a way, it's worse that you didn't know it because you were responsible for knowing it. So here are the elements of a violation of the general duty clause. So OSHA must show that a workplace hazard was allowed to exist, that the hazard was or should have been recognized by the employer. Again, that constructive knowledge. The hazard caused or was likely to cause death or serious physical injury. And this is, though, the one, again, so we've talked before about the first three are kind of obvious. This one gives us an employer a little bit of leeway. Feasible means exist to abate the hazard and were not used. So again, going back to the typing example, OSHA does not require that we make all typists slow down to the point that they type no more than 5 words a minute. I mean, I suppose if typists only typed 5 words a minute, no one would get carpal tunnel from typing, right? But that's not feasible. But requiring your typist to type 100 words a minute probably is not safe, at least if the typist is typing for really extended periods of time. So having some reduction in the expectation about typing speed could be a feasible means. But, even though it doesn't defy the laws of physics or to have people only type 5 words a minute, that wouldn't be feasible. So there is some rule of reasonableness here within the general duty clause. I'm going to be honest with you, though, OSHA is not known for its reasonableness. It's known for protecting workers. That's its job. And so what the employer considers feasible may be very different than what OSHA considers feasible. Okay, so let's look at some specific issues that arise under the general duty clause. One could be intentional actions. People who, what would be an example? Who subvert safety equipment, who to make the job easier, to do things along those lines. Bullying, people who shove people. Let's say they're on safety equipment and they shove people in ways that might cause them to fall. Or let's say I'm a forklift driver and I think it's funny to try to run people over or try to scare people by who are on foot, pedestrians in that situation. Workplace violence. This is a big issue with stores like 7-Eleven. The fact that the risk comes from outside the work environment, for example, people who are coming into the store from the community who may want to rob the store, that isn't a defense. You can't say, well, we didn't know that Bob the robber was going to come to our facility at this particular time on this particular date. No, the business needs to think through how it's going to protect its employees in that situation. And there's lots of different ways that workplace violence, can be reduced. Having panic buttons, having glass on the facility that is bulletproof, having great lighting around the facility, having reduced hours so that the place isn't open, at 2 in the morning, those types of things. There can be lots of different, having more than one person in the facility at a particular time. So that there can be, if the situation does escalate, there can be more than one person to handle the situation. To reduce the likelihood of violence in the workplace, employers should establish a complaint process for employees to be able to warn the employer of potential violence. And again, it can be from external, but it can also be internal. We've all seen stories about how a particular worker maybe gets fired and then comes back the next day and harms some people in the workplace. Well, those would be OSHA situations. And so if an employee says, employee starts getting nervous about a coworker who makes threats or acts irrationally, then there should be a process by which the employee can alert management. Hey, Bob over there's, he's not doing well. He's saying some things that are scaring us, and we need you to address those issues. And so that would be a good tool for the employer to have. That would be good evidence of protection of the general duty clause, to have that kind of complaint process. And then, of course, to take those types of complaints seriously when they happen. Let's talk about employer defenses. So generally speaking, there aren't a lot of employer defenses. An employer controls and establishes the workplace. And so if things go wrong, it really is the employer's fault. Here are some, though. We have the de minimis violation. We've already talked about this one a little bit earlier on, so let's just do a refresher. And this is, again, a good term to add to your Quizlet, where the violation of a federal safety rule or regulation has no direct or immediate relationship to safety or health. The violation is de minimis, and an OSHA citation is not appropriate. Another is unforeseeable employee misconduct. Who would have ever thought Bob would do something that crazy at work? Imagine an employee who brings firecrackers to the workplace and starts setting them off in the workplace. I mean, who would have thought anybody would do that? What would the employer have to prove? That established work rules prevent the violation, that those rules were communicated to employees, that the employer monitored the workplace for safety violations, and enforced the rules where violations were discovered. In other words, discharged or disciplined workers who didn't follow those rules. So that would be an example. You should have a rule that says no fireworks. I mean, it wouldn't have to be that specific, but no, unsafe devices be brought into the facility or something along those lines. Other examples where the employer won't be held responsible is when the employee is reckless. Not the employer being reckless, of course, the employer is going to be responsible for that, but when the individual worker was acted with a conscious disregard for safety, conscious failure to use due care. Now, of course, if this is the employee, this would assume this is employee's his first instance of recklessness. And let's say it didn't result in an injury the first time. Well, the employer should fire that employee or at least give a very stern discipline to that employee. An employee who's repeatedly reckless, the employer is going to become responsible for, because the employer knows that this employee is reckless. Okay, let's consider the greater hazard defense. This is an important one. I would say of the ones we're going to talk about, this is one of the more important categories. An employer may use the greater hazard defense in an OSHA violation where the hazards of compliance are greater than the hazards of noncompliance, where alternative means of protection are unavailable, and where a variance was not available. So let's go back to the example that I gave of, OSHA requires A, and this employer goes with B, which is even better. And everybody agrees B is better. In the example I used before, we had the spray that somehow magically protected us from the virus. But OSHA still required that we all wear the masks. Well, you can spray yourself with this safety spray and still wear a mask. So there's no tension here between these two. You can do both. There may be no point in doing A once you're doing B, but you can still do A. It's not physically impossible. But let's imagine that these two tools are irreconcilable. If you do B, you just absolutely can't do A. It's physically impossible to do A under those circumstances. For example, you buy a better ventilator that's clearly safer, and everybody agrees it's safer than the OSHA required ventilator. Well, a person can only wear one ventilator at a time. And so if OSHA comes in and says, well, we're citing you because you didn't use the required ventilator. But then you say, but my employees use the better ventilator, B, and everyone agrees it's better, and everybody agrees it's impossible to use both A and B ventilator at the same time. Well, that's when you have access to the greater hazard defense. Another basis can be impossibility. If it was impossible to use whatever the rule was under those circumstances. For example, there was an urgent situation, an emergency, and usually a person has to suit up in certain protective gear, but it was not possible to go through those tasks to suit up in the protective gear because lives were at risk. And so people dashed in without wearing the safety gear to preserve life. Well, that would be a case of impossibility. And there even can be economic infeasibility, but don't count on this as the employer. In the light of the custom and practice of the industry, an employer can defend noncompliance on the ground that it's economically infeasible to comply. But keep in mind our Casey the Donovan case that we talked about earlier, where, again, there's no cost-benefit analysis under these circumstances. So an employer that says it would bankrupt us to follow this rule is not likely to get a lot of sympathy from OSHA. Then, of course, statute of limitations. If OSHA waits too long to issue the citation, the employer is safe. And 6 months is the period that OSHA has to cite from the date of whatever that incident was. Let's consider this fact pattern. Coyote Tools takes all reasonable precautions to guard employees against known hazards in its production facilities. So again, general duty clause is being satisfied. It's also following all the OSHA rules. However, Bob, an employee, found many of the precautions too cumbersome to follow. Bob is injured when he secretly circumvents these precautions. Coyote Tools will not be liable as the harm was a result of reckless behavior on Bob's part. Now, again, if Coyote knew Bob was doing this, or should have known because Bob's actions were pretty obvious, then Coyote might still be citable under those circumstances. Let's consider this case. May an employee lawfully use a self-help remedy to refuse to follow an employer's directive in the workplace? And the answer here is yes. Whirlpool, this particular Whirlpool factory had several accidents in a certain part of their facility. In fact, it had a fatality. Some workers were told to go and do some repair work there, and their reaction was, it's not safe. I don't want to die. I don't want to get badly injured. The workers were told, do it. And the workers said, no, we're not going to. They were issued reprimands and as a result of refusing to do an order. And the court held that the act does not require an employee to die, isn't that nice, or become injured. Employees are entitled to disobey a work directive if it would violate the general or specific duty requirements. So an employee does not have to put himself or herself at risk if he or she knows that that particular situation violates OSHA rules. The employee can refuse to continue in that action. You don't need to know the name of this case, but you do need to know this concept. At this point, I'm going to go ahead and stop the presentation. In our next lecture, we'll go on and talk about prevention and enforcement, the scope and application of OSHA, and the record-keeping requirements. We'll also talk about workers' compensation law, especially as it works in Texas. I thank you for your attention. I hope this information has been helpful for you, and I hope you have a wonderful day. As always, if you have questions about the material, please feel free to pop into my office hours. Thank you so much.